Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur. Hello everyone. Today we are going to talk about major features of Indian Constitution. Our Constitution has adopted the best features of the most of the major constitutions of the world as per the needs of the country. Though borrowed from many constitutions around the world, the of India has several salient features that distinguish it from the constitution of other countries. So let's discuss few major salient features of the constitution. The very first point is written constitution. Constitution are classified into written like the American Constitution or unwritten like the British Constitution. The Constitution of India has the distinction of being the lengthiest and most detailed constitutional document the world has so far produced. In other words, the Constitution of India is the lengthiest of all the written constitution of the world. It is a very comprehensive, elaborative and detailed document. The factors that contribute to the elephantine size of the Indian Constitution are geographical factors, that is the vastness of the country and its diversity; historical factors, for instance, the influence of Government of India Act 1935, which was bulky; single constitution for both the center and the states; the dominance of legal luminaries in the Constituent Assembly. The Constitution of India contains not only the fundamental principles of governance but also detailed administrative provisions. Both judiciable and non-judiciable rights are included in the Constitution. Now, before I go ahead, it is very important to discuss that why and how these points are drawn from various sources. The Constitution of India has borrowed most of its provision from the Constitution of various other countries, as well as from the Government of India. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the known constitution of the world. The structural part of the Constitution is to a large extent derived from Government of India Act 1935. The philosophical part of the Constitution, fundamental rights and directive principles, derive its inspiration from American or Irish Constitution, respectively. The political part of the Constitution, the principle of cabinet government, and relations between the executive and legislatures have been largely drawn from British Constitution. Let's discuss that how the blend of rigidity and flexibility makes our Constitution very unique. Constitutions are classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment. For example, the American Constitution. A flexible constitution is one that can be amended in the same manner as ordinary laws are made. For example, the British Constitution. So, the Indian Constitution is a unique example of a combination of rigidity and flexibility. A constitution may be called rigid or flexible on the basis of its amending procedures. The Indian Constitution provides for three types of amendments, ranging from simple to most difficult procedures, depending on the nature of the amendment. Now, let's discuss the blend of federal and unitary features. The Constitution of India establishes a federal form of government. It contains all the usual features of a federation, such as two governments, division of powers, written constitution, supremacy of the Constitution, the rigidity of the Constitution, independent judiciary and bicameralism. However, the Indian Constitution also contains a large number of unitary or non-federal features, such as a strong center, a single constitution, the appointment of a state governor by the center, all India services, an integral judiciary, and so on. Moreover, the term federation has nowhere been used in the constitution. Article 1 describes India as a union of states, which implies two things. Indian federation is not the result of an agreement by the states, and no state has a right to succeed from the federation. Hence, the Indian constitution have been variously described as federal in form but unitary in spirit, and it is also called quasi-federal. Now let's discuss parliamentary form of government. The Constitution of India has adopted for the British parliamentary system of government rather than the American presidential system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on the doctrine of separation of powers between two organs. The parliamentary system is also known as the Westminster model of government, responsible government and cabinet government. The constitution establishes the parliamentary system not only at the center but also in the states. In a parliamentary system, the role of Prime Minister has become so significant, and therefore it is called a prime ministerial government. Let's discuss few features of parliamentary government in India. Presence of real and nominal executives, majority party rule, collective responsibility of the executive to the legislature, membership of the ministers in the legislature, the leadership of the Prime Minister or the Chief Minister, dissolution of the lower house, Lok Sabha or Assembly. Indian Parliament is not a sovereign body like the British Parliament. Parliamentary government combined with an elected president at the Republic. Now let's discuss synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of Parliament in India is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Sorry. Just as the Indian Parliament system differs from British system, the scope of judicial review power of the Supreme Court of India is narrower than that of what exists in the US. This is because the American Constitution provides for due process of law against that of procedure established by law contained in the Indian Constitution. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court can declare parliamentary laws unconstitutional through its power of judicial review. The Parliament can amend the major portion of the Constitution through its constituent powers. Now, another important point is rule of law. According to the axiom, people are ruled by law but not by men. That is the basic truism that no man is infallible. The axiom is vital to a democracy. More important is the meaning that law is sovereign in democracy. The chief ingredient of law is custom, which is nothing but the habitual practices and beliefs of common people over a long number of years. In the final analysis, the rule of law means the sovereignty of the common and man's collective wisdom. Apart from the crucial meaning, the rule of law means a few things like there is no room for arbitrariness, Each individual enjoys some fundamental rights, and the highest judiciary is the final authority in maintaining sanctity of the law of the land. The Constitution of India has incorporated this principle in Part 3, and in order to provide meaning to Article 14, all are equal before law and all enjoy equal protection of laws. The promotion of Lok Adalats and the venture of the Supreme Court, known as public interest litigation, have been implemented. Also, as per today's law of the land, any litigant can appeal to the presiding judicial authority to argue the case by himself or seek legal assistance with the help of judiciary. Now, let's discuss another point: integrated and independent judiciary. India has a single integrated judicial system. Also, the Indian Constitution establishes independent judiciary by enabling the Indian judiciary to be free from influence of the executive and the legislature. The Supreme Court stands as the apex court of the judicial system. Below the Supreme Court are the high courts at the state level. Under a high court, there is a hierarchy of subordinates, that is district courts and the lower courts. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independence. Now let's discuss fundamental rights. Part 3 of Indian Constitution guarantees 6 fundamental rights to all citizens. Fundamental rights are the one of the important features of Indian Constitution. The Constitution contains the basic principle that every individual is entitled to enjoy certain rights as a human being. And enjoyment of such right does not depend upon the will of any majority or minority. No majority has the right to abrogate such rights, and fundamental rights are meant for promoting the idea of political democracy. They operate as limitation on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, that is enforceable by the courts for their violation. Now, let's discuss another points: directive principles of state policy. According to Dr. B.R. Ambedkar, the directive principles of state policy is a novel feature of the Indian Constitution. They are enumerated in Part 4 of the Constitution. The directive principles were included in our Constitution in order to provide social and economic justice to our people. Directive principles aim at establishing a welfare state in India, where there will be no concentration of wealth in the hands of a few. They are non-justiciable in nature. For example, in the Minerva Mill case, 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between fundamental rights and directive principles. Another important point to discuss is fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens. Fundamental duties were added to our Constitution by the 42nd Amendment Act of 1976 on the recommendation of Swaran Singh Committee. It lays down a list of 10 fundamental duties for all citizens of India. But later, in 86th Constitutional Amendment Act of 2002, added one more fundamental duty. While the rights are given as guarantees to the people, the duties are obligations that every citizen is expected to perform. However, like the directive principles of state policy, the duties are also non-justiciable in nature. There is a total of 11 fundamental duties altogether. Let's discuss Indian secularism. The Constitution of India stands for a secular state. Hence, it does not uphold any particular religion as the official language of the Indian state. The distinguishing features of a secular democracy contemplated by the Constitution of India are: the state will not identify itself with or be controlled by any religion, while the state guarantees everyone the right to profess whatever religion one chooses to follow, which includes also the right to be antagonist or an atheist. It will not accord preferential treatment to any of them. No discrimination will be shown by the state against any person on account of his religion or faith. The right of every citizen, subject to any general condition, to enter any office under the state will be equal to that of fellow citizens. Political equality will entitle any Indian citizen to seek the highest office under the state is the heart and soul of secularism and envisaged by Constitution. The conception aims to establish a secular state. This doesn't mean that the state of India is anti-religious. The Western concept of secularism connotes a complete separation between the religion and the state. That is also called negative concept of secularism. But the Indian Constitution embodies the positive concept of secularism, that is, equal respect to all religions or protecting all religions equally. Moreover, the Constitution has also abolished the old system of communal representation. However, it provides for temporary reservation of seats for the scheduled caste and scheduled tribes to ensure adequate representation to them. Another important point is universal adult franchise. Indian democracy functions on the basis of one person, one vote. Every citizen of India who is 18 years of age or above is entitled to vote in the elections, irrespective of caste, gender, race, religion, or status. The Indian Constitution establishes political equality in India through the method of universal adult franchise. It is very important to notice that India provides single citizenship. In a federal state, usually, the citizens enjoy double citizenship, as in the case in the US. In India, there is only single citizenship. It means that every Indian is a citizen of India, irrespective of the place of his or her residence or place of birth. He or she is not a citizen of the constituent state like Jharkhand, Uttaranchal or Chhattisgarh, to which he/she may belong, but remains a citizen of India. All the citizens of India can secure employment anywhere in the country and enjoy all the rights equally in all parts of India. The constitution makers deliberately opted for single citizenship to eliminate regionalism and disintegration tendencies. Single citizenship can undoubtedly forge a sense of unity among the people of India. Independent bodies. The Constitution of India not only provides for the legislative, executive and judicial organs of the government, center and state, but also establishes certain independent bodies. They are envisaged by the Constitution as the bulwarks of the democratic system of government. It is very important to discuss emergency provisions as well. The Constitution of India makers also foresaw that there could be situations when the government could not be able to run as in ordinary times. To cope with such situation, the Constitution elaborates an emergency provisions. There are three types of emergencies. First, emergency caused by war, external aggression or armed rebellion, that is Article 352. Emergency arising out of the failure of constitutional machinery in states, that is Article 356 and 365. Financial emergency, Article 360. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system and the constitution. During an emergency, the central government becomes all powerful and the states go into total control of the center. The kind of transformation of the political system from federal during normal times to unitary during an emergency is a unique feature of Indian Constitution. Let's discuss another point, that is three-tier system or called three-tier government. Ordinarily, the Indian Constitution provided a dual polity and contained provisions with regard to the organization and powers of the state and center. Later, 73rd and 74th Constitutional Amendment Acts 1992 have added a three-tier of government, that is local government, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the panchayats, rural local government, by adding Part 9 and a new Schedule 11 to the Constitution. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities, urban local government, by adding a new Part 9A and new Schedule 12 to the Constitution. It is very important for the students to listen to this carefully so that they can understand that how municipalities have been added to constitutional recognition. So, in 74th Amendment Act of 1992 gave constitutional recognition to the municipalities under local government by adding Part 9A and a new Schedule 12 to the Constitution. Another important factor is the panchayats, rural governments have been added by adding a new Part 9 and Schedule 11 to the Constitution. Lastly, we will discuss cooperative societies. The 97th Constitutional Amendment Act of 2011 gave constitutional status and protection of cooperative societies. In this context, it made the following three changes to the Constitution. It made the right to form cooperative societies a fundamental right, Article 19. It included a new directive principle of state policies on the promotion of cooperative societies, Article 43B. It added a new Part 9B in the Constitution, which is entitled the Cooperative Societies, Article 243 to 243T. The new Part 9B contains various provisions to ensure that cooperative societies in the country functions in a democratic, professional, autonomous and economically sound manner. It empowers the Parliament in respect of multi-state cooperative societies and the state legislatures in respect of other cooperative societies to make appropriate law. I guess that's all for understanding the unique features of Indian Constitution. These are the main highlights on the basis of what the Constitution have been framed. Thank you so much.